just reflect on one issue that I want to raise. Have your lordships ever heard for the president withholding a bill?
Sorry?
Since independence, have your lordships ever heard of the president withholding the bill?
I think there was one occasion during one president's period.
That was for some other reason.
Maybe, but there was.
Yeah, but
I recollect in my memory.
Yes, I'm aware of that particular, but that was with another intent altogether. But be that as it may, Malas, what's the reason for that? Let's just, because the parliament is sovereign.
Will of the people.
Will of the people. Parliament is sovereign. Executive cannot. And this president, a president is an elected president. Even then, because there's an element of urgency, the will of the people has to be implemented immediately. And if the president doesn't exercise that leeway, in what circumstances should the governor exercise it? He's only an elected, he's not elected. Now, the other constitutional issue. Mullahs,
Yes.
The other issue is when the bill becomes law, there is a presumption of constitutionality.
Yes.
Presumption.
Always a presumption about it.
Always a presumption of constitutionality.
And the burden is on who challenges it. And
Correct.
it's a very
Correct.
strong burden.
Correct. Now, I explained to your lordships how actually a bill comes into being yesterday when I elaborated the manner in which the law ministries, all these aspects are looked at before a bill is introduced. And the legislation is not concerned with the constitutionality of the bill. That's the domain of your lordships. In fact, these questions are raised in Parliament several times. And some of our members say, but this bill is unconstitutional because it...
According to you, the legislative competence of the bill cannot be examined by the governor.
Exactly. Cannot be. That's why this bogey of timelines and all that is not necessary.
Because the written constitution is lost if we take that position.
No, I'll tell your lordships what that position is. I'm just explaining at the moment, Mullahs, that as far as the legislation is concerned, the parliament, when it passes a bill being a sovereign authority, is not looking at its constitutionality. Several times, Mullahs, we pass a bill. Ultimately, it may be provisions are struck down by this court. Sometimes the legislation itself is struck down. But at the stage of introducing it and passing it, we don't test it. Right? So if we don't test it, Mullahs, what are the three grounds on which you can test constitutionality? Just look at it from constitutional principles. Number one, will the president say, in case it's a bill introduced in parliament, that you are entrenching upon a power of the state in list 2? That's the 254 issue. Will he send it back on that ground? That's one area of testing constitutionality. 2, will he say you are violating a fundamental right of citizens? That's 2. 3, you don't have capacity. These are only 3 grounds, Mullahs, on which a legislation can be challenged. There is no 4th ground. All this will be challenged in a court of law by citizens or by somebody else. So it's in the rarest of rare cases, Mullahs, that a governor will say, no, I cannot decide it for whatever reason. Supposing, Mullahs, in a state university, the chancellor is the governor. Just to give an example. And Mullahs, a legislation is passed that the chancellor should not be the governor. What possibility will he have to clear this legislation? Supposing in a state, there is an issue of private money lenders are charging an interest of 30–40%. And the state wants to pass a legislation, no, this shouldn't be done. It should not be more than 12%. Fundamental question is, what is that leeway? And if you give that power,
Makes the law relating to shipping, any number of entries in the...
That's right. That's capacity violation of constitutional provision. I'm not disputing that, Mullahs. But will the president raise it, or will it allow it to be raised in a court of law? Because, Mullahs, at that stage, this issue is not to be considered as a matter of constitutional law. The remedies are available under the Constitution. If it's remediless, I can understand. Because it will result in a quagmire, Mullahs.
But suppose if we find that the legislation is repugnant to any central legislation, can it not reserve for the opinion of the president?
Mullahs, normally, Mullahs, there's the constitutionality of the presumption of constitutionality. Normally, no. That will apply to a bill also. It's been passed in the legislature.
No, but
It's a rare case. It'll be a rare case.
it's a rare case, but some like my Justice Narasimha give an example. If the state legislature passes a bill or legislative law on the subject of shipping,
In the area of shipping.
Citizenship, take any number.
Let's assume, Mullahs, first of all, your lordships, these fact situations are never before the court. Mullahs, the point is, you are now taking an example that has never happened in the history of of the Republic of India, and testing the proposition on the basis of 200 and 201.
therefore the question that we are putting is whether in such a case, can the governor not exercise his first option or second option?
It's in the rarest of rare cases, Mullahs. I'm saying that has never happened before. We are now assuming something that Mullahs, legislations are not passed like this, or not, bills are not introduced like this. Mullahs, supposing there is a price regulation in respect of drugs, Mullahs, how these bills are not introduced? You will ask the Ministry of Health what's the impact of it on the consumer. You will ask the Ministry of Consumer Affairs what's going to be the impact. You will ask whether under the drug control order you can do it or not. Should you do it? Should you do it to an essential drug? Should you do it to another drug? Then it goes to the Ministry of Law. These legislations are not passed on the ipsic dixit of ministers, Mullahs. Therefore, I understand what my Lord is saying, but it's never happened.
So therefore, Mr. Sibal, even according to you, the governor will have to apply his mind at least to find out whether the proposed bill is within the constitutional framework or not.
Well, the problem is, I'm sorry.
Two expressions which I am again repeating, shall declare presupposes application of mind by the governor. And that application of mind, we can, of course, you can argue that what will be the contours of that application.
Yes,
The other side can also argue what should be.
correct.
So within that framework, neither he can be treated as a postman, nor he can be a super legislative power to sit over
Absolutely. No, Your Lordship is right.
legislative assembly.
Your Lordship, in fact, asked that question and said that I would address it, Mullahs. Now, let me address it straight away. Mullahs, the bill is sent to him. He doesn't have a formal declaration to be made. He assents to it. His assent is a declaration. Right, Mullahs? There has to be no formal declaration. Two,
Grant of an assent is a declaration.
is a declaration. That's right. So there's no formal declaration, right? Two, he sends it back. Let's say he sends it back. It's a declaration. It's a declaration that he's sending it back and he's withholding assent. They go hand in hand.
If he sends to presidential assent, again it's a declaration.
That's right. Therefore, and it is withholding. Kindly note the word. Withholding assent is coterminous with his sending it to the legislature and sending it to the president.
What gets excluded is only a pocket veto.
That's correct. Correct. It's completely excluded. Now, the question that what my Lord asked, so declaration is clear, Mullahs. It is the act of the governor which itself is a declaration. There is no formal declaration to be made, right? What your lordships are looking at, what are the contours of that? Namely, supposing he starts giving reasons. That for this reason, I am sending it back to you. Let's assume, Mullahs. Are those reasons justiciable? Parliament, the state legislature will say, we don't agree. The end of the matter. Even if he has reasons. He'll have to pass it. If it sends it to the president, Mullahs, and the president sends it back with the same, and still the legislature passes it, it'll have to be passed. So, Mullahs, the process is what's important. The sovereignty of the, sovereignty of the legislature is as significant as the sovereignty of parliament. And supposing all these, I'm sorry.
Assigned to them.
That's right. Otherwise, it'll be a violation of separation of powers. So he can do that. So the question is, how soon should he do that? That's ultimately we boil down to that. He can do that, but how soon should he do that? The president does it forthwith, never delays it. Should the governor be allowed to delay it? That's the question. Right? Mullah, the home cannot function unless there is marital accord, Mullah. That equally applies to institutions. You can't create a discord. The marriage will break down. The constitutional machinery will break down. And the court must attempt to ensure there is no area of discord. So there the key words are as soon as possible. It was not later than 6 weeks. They said no, which means forthwith. Immediacy, element of immediacy. Why? The will of the people. Why should people have to wait if the rate of interest charged by money lenders is going to be 50%? Why should fishermen wait if the law is to be regulated as far as fisheries are concerned? Why should that wait? What's the reason? And the governor cannot say, I had no time. Well, there will be extraordinary situations, which is why it is very dangerous to lay down laws without context. This is a very dangerous area. Because then you give examples which are not before you. And then you test those examples on the basis of constitutionality. And those examples may be completely unrelated to reality. So you're given a situation where an argument is being made, give that discretion. Of course, the argument is extreme. He says, if I don't decide a bill for 3 years, it doesn't matter, or 5 years, it doesn't matter, because it is not justiciable. Constitutionalism has to be worked out.
No, the argument is that the governor has the power to permanently withhold it.
That's correct. So that's one extreme argument. If your lordships don't agree with that, we still have to find contours within which it must work, Mullah. The constitution must work in a manner that is consistent with the parameters set out in the context of separation of powers and the primacy of the legislature. So, Mullah, that's what I wanted to place before you, Mullah, before I move on, Mullah. Would my lords be